tuimarike, nishike mkono, nikushike mkono, twende mbele pamoja, niongoze.
Yes, and today in this capacity I'm here as one of the people behind this workshop. In the last 1 year we've been doing them, just apart from a few months that we took a break, and I'm glad we are starting with one. So this is the second one for this year. We had the first one a few weeks back, and we are happy. The turnout today is good, and also for those ones who came last time, thank you so much. Tuzidi kusoma, sindio? Yes, so today we have the Copyright Awareness Workshop 2. This idea, when it came about, it was for us to have someone in this space who has a proper understanding of copyright. And we could have none other than Mrs. Sharon. Yes, so if you are new to this place is called the Permanent Presidential Music Commission. And it's a government department that is in charge of music. They do a lot of programs which are centered around preservation of music, preparation of music during national days. In case you need more information about PPMC, kindly visit the website, ppmc.go.ke. You'll be able to interact with a lot of what goes on here. So on behalf of the director, Dr. Donald Otoyo, we would like to welcome you officially here. Feel free to ask any question, and we're looking forward to having a wonderful session. Yes, so I would like to do a brief introduction of you, if you'll allow me. Yeah. Yes, so Mrs. Sharon Chahale Wata is an advocate of the High Court of Kenya. She holds an LLB from the University of Nairobi and LLM in Intellectual Property Law from the University of Turin, Italy. She has also undertaken courses in Senior Management and Strategic Leadership Development at the Kenya School of Government. She is currently the Deputy Director of Training and Research at the Kenya Copyright Board, an accomplished intellectual property lawyer with over 14 years industry experience, having served as copyright prosecutor, CEO of a collective management organization, as well as intellectual property trainer. Yes, she's a wonderful trainer. You will see today if you are interacting with her for the first time today. So she has past consultancy experience in various areas, including intellectual property law, environmental law, human rights, democracy and governance issues. Her leadership, credibility, and knowledge in IP has been recognized as highly dependable. So with that, let's kindly welcome Mrs. Sharon. Makofi tafadhali. Yeah, thank you so much. Karibu.
Thank you. Good afternoon. Good afternoon.
Afternoon.
Watu wamejam. Sorry I'm late. Last time you guys kept me waiting. So today I knew mnakula ugali kwanza, sijui mpite kwa kiosk kibandaski, then you reach here. So I was a bit relaxed. But thank you for coming. I'm sure there are more people coming. I recognize a few people who were here last time. Boy, siwe nilituambiwe ni soja. I saw Joy. You were here last time? Yeah, the ones who are new, ndio nimesikia tu mkisema mnataka kujua vitu zenye niliwaambia last time. But we'll find a way of going along. As he said, this is a partnership between Kekobo and PPMC to just try and reach out to our creatives with the knowledge we need to impact. So we started, when was that? 2-3 weeks ago.
Yes.
And that's the time we were talking about what is copyright, how do I register, what, all those things. So today we were really going to focus on contracts and the issue of infringement. But maybe as a recap, I had, for example, let me use the example of the script writer person who said she wants to know how copyright would apply to her. Yeah, so a script is a literary work, and we said that copyright covers such works. Literary, musical works, film, audiovisual works, computer software and computer programs, architectural designs. And we said copyright covers you how? It gives you the right to control how your work is used and by who. So it is you to decide, nimejenga nyumba nataka kuiuza, or I want to lease it out. So it is you to decide, I have this script, I want to sell it, or I want to license it, or I want to give it out for free. That's the right that copyright is giving you. And then copyright is telling me as a user, if I want to access, I need to access it legally with permission or with a license. So you get permission from the owner, or where you cannot get permission from the owner, you pay for a license for it. So I'm trying to collapse a whole LLM unit in a few minutes, yeah? Generally, that's the idea of copyright. That's what we said. That if you want to access, you pay for it or you ask for it. And last time, one of the examples we gave was the examples of cover songs that people don't usually ask for permissions, yeah? But you need to ask for permission even for a cover song, because sometimes the cover song becomes more popular than the original, and it can even make more money than the original, yeah? So you'll get in trouble if you don't have the permission. So generally, that's what we said copyright was. So today, I wanted us to focus on contracts and the whole issue of infringement. What do I do when my work is infringed upon? Where can I go? What do I do? But maybe I'll start with a bit of introduction about Kekobo, because I had someone introducing themselves and saying, I want to know what plans you have. Yeah. So Kekobo is a state corporation that is registered, is created by the Copyright Act. And we are mandated to administer and enforce copyright in Kenya. So when I talk about administer, we are the ones who work on the law, the copyright law, and make sure iko sawa. So for example, we get feedback that this is missing in the law, or this is not working, or this is new. We are the ones to make sure that the law is sufficient to provide for everything. We are the ones who advise the government on what copyright treaties are good for us to sign and how good they will be for us. And we make sure the treaties are signed. And once they are signed, we make sure our law reflects that treaty that we have signed. An example is the Marrakesh Treaty. It's a treaty that provided exceptions for people, visually impaired people. So generally, tumesema, copyright says you can't take. You have to ask for permission or pay for a license. But there are instances that the law has allowed you to use without permission or without paying. So like the people who are visually impaired and blind, they are allowed to use. They can take your script. What did you say your name was? Pardon? Nemo. A blind person can take your script and change it into Braille so that they can be able to read it without your permission, because the law has allowed them. We have given exceptions for people with visual impairments. So once we signed that Marrakesh Treaty, we needed to make sure our law makes that provision. So we made an amendment in 2019 to provide for that, yeah? Another case example is like for parody. You've all seen what Eric Omondi usually does with music online, yeah? You've seen his video, How to Be Rose Muhando. Have you seen it? It's really funny. When you see, it is Eric dressed up like Rose, but what you're hearing in the background is the real Rose's video, yeah? Normally, you wouldn't be allowed to do that, but he's doing it for parody, and it's an exception in the law. There's been a lot of debate about that, whether it's right, because even that video of his on YouTube, it will make money. Yeah, so that's the debate there. Like, hata kama kuna exception, is he sharing this money? But as it stands now, the Copyright Act provides for an exception for parody, okay? So Kekobo normally would work on the law, make sure the treaties that we need to sign are signed. Then another big part of what we do is training. And that's why sometimes when people complain a lot and they're throwing shade all over, I'm like, you just do it. I have a mandate to do. I need to train people. Nitaendelea too, because I can't stop, yeah? If I could, I would go to 47 countries if I had the money. Because I have realized there's so much need for the information, and people want it, and people need it. But sometimes pesa inaleta shida. Labda pesa imetukataa hii Kenya, I don't know. But that's the plan. That would be the plan. So last year, we had a project that was supported by the inaitwa sports fund, inaitwaje in full? Yeah, social, cultural, sports and development fund, something like that, SASTEF. They supported us to go to 8 counties, and we were targeting 300 creatives in every county. So we did Nyeri, Isiolo, Embu, Machakos, Kakamega, Kisumu, Kericho, and Mombasa. And we were training artists on issues of copyright. How do I make money with my copyright? How, and then we put something on financial management from our finance people. Because again, we realize creatives, sometimes we live an online life, that we look very rich, but kwa ground, vitu ni different. Yeah, so we'd incorporate all that. We did 8 counties. Now we are doing phase 2 of that, and we just started. Last week, we did Kisii and Narok. And so we're going to do 4 other counties. So one of the things I urge creatives, if you hear there's something like this, kuja tu, hata kama unajua, you might pick something different or a different perspective, but there's also networking that you can do while you're in such kind of spaces, yeah? Yeah, so we do training. We also offer legal services, legal advice. We will read a contract for you. We will advise you for free. Okay, we don't charge you because we're a government institution. So if you come and say, I have a contract, I would like somebody to help me read or interpret, or I'd like legal advice on a copyright issue, you will get that service for free. Then of course we do registration of copyright. You can register your copyright with us. Right now we've gone online. So you don't have to come to Kekobo. It's a portal that you have to go to. I gave you guys last time, nrr.copyright.go.ke. So you can always register your copyright with us. We also do supervision and licensing of CMOs. What else? Enforcement. We do enforcement. You can come and report to us whenever your work has been infringed upon, and we are able to help you take it through. But remember, if you want us to deal with it, it would be a criminal. And I'll tell you as we go along in terms of enforcement, it will be criminal. But then what criminal does is that if he's found guilty and he's charged a fine, the fine goes to the state. You don't get anything. So if you want to get money or to get damages or compensation, you have to file a civil matter in court, yeah? So yeah, that one we'll see a little more as we go along. So that was just kind of a recap, yeah, before we start today's session. But as we go along, I hope we'll also have a little more time to do a bit of question and answer, yeah? Then we can deal with your questions. So can we move on to contracts? Yeah, so contracts are things we know. And since we are creatives, I assume that we have done contracts before. We have signed contracts before. We have gotten into contracts before, yeah? My friend, you said you know everything about copyright, most things. So, yeah. What is a contract? Some information. What would you describe a contract to be? Oh, by the way, you guys, he introduced me very professionally. So let me tell you my other life, okay? So in my other life, I sing also, yeah? With gospel groups, and I sing now in my church. Ukitaka kuniona Sunday, kuja Nairobi Baptist Church, I'll be leading worship. Wenye hamjaonoka mnaweza kuja tu pia. Jiambie tu nakuja kuona kama huyu ni msanii wa kweli. Na unajua hapo Sunday you don't computerize your voice. It's the real one that comes out. So ikigwara inagwara tu. I used to be in another church where if you sang badly, they just zima your mic. Una shout, ukitoka hapo, your voice is gone. Kumbe ulikuwa umechoma. So that's my other life. My other life, I'm also an artist. I used to do painting and drawing when I had the time when I was younger. And have you ever seen December how people do Merry Christmas kwa window in town? Yes, I used to do that. But now at my age, sina mgongo ya kuinama town na fanya hizo vitu. Nilipita hiyo stage. That was some stage in my life. I love to read. I read a lot and I also write a lot. I write for a magazine in the UK called The Copyright Lawyer. I also teach at Daystar University Law School part-time. So I'm a teacher. So mimi ulizanga watu maswali. So nikikuuliza swali usikasirike ati amenimulika Peter. Leo nimekumit na kujua jina lakini leo nitakumulika. Yeah, nikikuuliza swali usikasirike. I like for us to be interactive, yeah? So it's not boring. We don't have to make this thing boring, yeah? So our friend was about to tell us, what do you think a contract is?
Okay, I think a contract is an agreement between individuals, between institutions, or between parties to come up to an agreement for a certain period of time.
For a certain period of time.
Yes.
Okay. Anybody else wants to try?
I just want to add on what he said is that a contract is legally binding. It could be between two parties for a certain period of time, but it's legally binding. So if there's a breach, then there's a consequence.
Ni kama mulikuwa na mwa Kenya. Somebody leaked my PowerPoint. Na sikuwa nimeituma. A contract is a legally binding agreement. So usitoe hiyo legally binding. Shika hiyo, si ndio? Agreement between two or more parties. They could even be three. So me, him, and him could sign a contract, the three of us, yeah? That is entered into voluntarily. Why the law just talks about parties is because the law says there are two people. There's a natural person and there's an institute person. So they see a company as another person, yeah? So it says two or more parties that are entered into voluntarily. Again, underline that one. Lazima ikuwe voluntary. Okay? Lazima ikuwe voluntary. The whole issue of entering into the contract, it has to be voluntary. It has to be voluntary. That one, you cannot remove that. The moment it is forced, then that is a reason to nullify the validity of that contract. That's why I want us to take the voluntarily. It has to be unataka kuingia hiyo contract.
So maybe you will cover it because I don't know if clauses would be something that's done today. This thing of exit clause. So like there's one global streaming service. They have put it in their supply chain or partners, you know, because they collect produced works and then put on their streaming platform about servitude. This is whereby you find that, you've signed that I must produce 3 albums, but maybe after 1-2 albums, the conditions are not good and whatnot. So
yeah, but you have signed. You've just said you have signed that you will do this, but then maybe the conditions change. That's why you want to change your mind. But initially you signed. Initially you agreed. So we are still at this point. Bado tuko hapa. We usikimbishe wase. Mse ukimkimbisha atatoroka. This is free advice, eh? We are still at here. Unataka kuingia kwa hiyo contract. That's where we are. Voluntary. So we will talk about once you ingia, the conditions and whatever, and exit clause lazima ikuwe kwa any contract. Eh? Contracts are the bedrock of the system, of course, that governs the creation and dissemination. Because the whole of the copyright system is creation and dissemination. You must have the law of demand and supply. There's a demand for music, there's a supply. There's a creator, there's a user. So you need to govern that relationship, yeah? So they regulate the relationship, of course, between you as a rights holder and the user. And the whole idea also is to balance the interests. Because the user has an interest to use copyright protected material, and the creator also has an interest to create and to sell. But this interest must balance. You create and you bar people from getting it, hata wewe itakusaidia. If you create and sit with it in your house, will it help you? No. So you have to find a way. Copyright tries to find a way of balancing these interests. Huyu ni creator, huyu ni user, ana need kutumia, but you want huyu creator pia to benefit. So you need to find a balance between the two, and the law helps us to do that, yeah? So the role of contracts in copyright, it ensures there's a financial reward for the rights holder. Because again, why are you making films, Peter? Obvious, unataka kutengeneza pesa, right? Otherwise you won't make, and you won't invest. You won't put your money there if you know you'll get nothing. So copyright law is there to ensure that you get a financial reward, yeah? And then the contract would dictate the use and the behavior. So it will have to spell out ownership, who is the owner of the copyright, who are the owners, kama ni wawili, watatu, and you'll see as we go along, yeah? It spells out the formalities of the contracts. We have agreed this, we have thought about this. It outlines the scope of the rights granted. Last time we talked about rights, and one of the rights is adaptation, translation. So you can say, I am licensing out my song for translation. But don't do public performance, or don't do this, because there are many rights. There's reproduction, there's public performance, there's broadcast, there's all this. So the contract might say, you're licensing out that song, that work, for these certain rights, but not this. Meaning, I have to stay within the rights you've granted me. So if you give me rights for translation, I am not supposed to do any other thing outside of that contract, yeah, just because you've given me a license, yeah? So it spells out the scope. In line with what you said, there's a time I was giving advice to a certain media house about some works they were putting online, and there's a certain space, let me call it online platform, yeah, that have a fine print provisions on the website, kadogo. And then so they asked me, interpret for us this. And when I took it to look at it, it had said, whenever you put your work on our platform, you're giving us an exclusive license to reproduce, sijui do what, all these things. And then it even went ahead to say, and by the way, you waive your moral right, which in law cannot be waived. It went on to say you waive your moral right, so if we use your photos or your whatever, you cannot sue. And I was like, okay, a lot of us don't know, because you've never read. So you'll just hear, I need to open this channel, I need to go to this platform, and you go. But we never read the provisions they have. Unfortunately, this is how contract law works. They have given the disclaimer and the thing on their website, so ukijiweka hapo, the assumption is that umekubali, voluntary. Okay? When you go to that platform and put your things there, it means you have accepted and agreed their terms and conditions. So that's why you need to be careful. So the contract would spell out the scope of the rights granted, the right to remuneration, the right to money, right to get money. I don't want us to do question and answer now.
If I can just ask, because I don't know, maybe you're withholding the name of the entity.
Yes, it was one of those platforms that I don't want to name.
Social media, streaming, or what kind of platform was it? And how can such a platform reproduce? Because I'm like, okay, is it that if
reproduction now can be online, yeah?
Is it that if another fan decides to make a cover because they saw it on their platform, or I'm wondering, how can a streaming platform, streaming is not a producer per se.
So the right to reproduction means make a copy. But when I'm online, sharing that is reproduction. Okay? If I scan something and send it on email to my colleagues, that is taken to be reproduction. if I download something online, that is taken to be reproduction. So when it comes to online, that is how it works. But if it's physical, reproduction means I make another CD, I make another book, then, so the contract would spell out, of course, remuneration, monies, yeah. Then effects of the contract on third parties, it would talk about that. And then revision and termination. So you need to have an exit clause, and you also need to provide for revision of the contract. So I usually tell people, contracts are not cast in stone. Unaweza ingia hapo na utaki, you can get out. There needs to be an exit clause or room to revise it, yeah? Maybe you have contracted with someone that you're going to do 1, 2, 3, and you figure there and you realize, I actually do not have the capacity to do that. You can renegotiate that contract. You may lose some money, but you can renegotiate. You can revise it, and you can exit the contract altogether. That should always be a clause inside the contract, yeah? Then, of course, confidentiality and non-disclosure agreements. The person was talking about pitching. This is what you need to always have, non-disclosure agreements. So when you go to pitch, you sign a non-disclosure agreement. I know for many artists I talk to, usually wanaogopa. You unasema, I'm taking a script to a media house. So unataka kujisell, so you don't want to say, guys, sign this non-disclosure. But it's very important. I have been an expert witness in a matter that was in court for a program. That someone was saying that they had the idea, and shortly they saw it being produced, the program being produced. So there was a matter in court about it, yeah? And the way they gave the idea, you're like, did you have an NDA? So it's usually my word against yours. I told Peter, I'm going to be at PPMC today. And he says, Huku niambia. It's just that. Nobody can know. Only the two of us know. So that's why the non-disclosure agreement will help. Because most Africans are tukwangi gentlemen and ladies. Munapenda kuruka. Then general role is to formalize new relationships and outline the various legal obligations. So basically, if I want to enter into a contractual relationship with you, we just need to formalize it and spell out our obligations. But also I tell people, especially creatives, it's also good to sign contracts because your work lives beyond you. Remember we said the duration of copyright is your whole life, and then 50 years plus. So if you died and the person who inherited your estate is still earning royalties from your work, and they have no idea of knowing the relationships you created, it's going to be difficult, yeah? Or if you are unwell and somebody else is managing your affairs, they need a contract to know, okay? So sometimes it's not even for you. It would even be for your family, for posterity, yeah? When I was growing up, my mother used to keep us accountable to where you're going. Okay, she was a teacher, so hiyo ni category ingine. And I used to be like, I'm very spontaneous. So sometimes I'd leave, hata sina mpango, and then mpango inakuja as you go, as you're on the go. You know that thing? Okay, squeeze is fanyangi hivyo, nimezeeka. But form inapatikana. Ama mtu anakupigia, kuna form. So she would always think, you didn't say where you were going and what you're going to do. And I would be like, I didn't even know. And she would even be like, how? How do you just leave? Hata hujui unaenda kufanya nini? But one thing she used to say, keeping accountable is also for your safety. If something happened to you, we know where to begin. If something happens to you, we know where to begin. And that's the thing with contracts, If something happens to you, and your spouse, for example, inherited your property, they would know where to begin if you have contracts. But if you don't have, zingine upotea. Yeah? Some of them, they'll get lost and your money will get lost. So the basic elements, there are certain basic elements that need to be in a contract. At least you look out for whenever you are signing a contract. I've listed them here, but I'm going to explain them one by one. Of course, the element of identification. All parties involved in the agreement must identify who they are in this stage, yeah? So for businesses, you have to put full legal name, registered office, address, all that. For individuals, full legal name. Wale wakupenda stage name, please. Eh? Sio stage name, legal name. Ni ile ya serikali ya ID. You need, because if, sometimes people call me Mama Imani, because that's my daughter's name. If I sign a contract as Mama Imani, how many Mama Imanis are there in Kenya? How would you prove it? Yeah? It's very difficult. So you need your full legal name. Yeah? For companies, it's also good for them to have a registration where they are physically. Yeah? Because utatafuta hiyo kampuni utashangaa. So you need to have them have proper identification. Yeah? Then an offer. An offer is a promise to do or not do something in exchange for something. So there needs to be an offer and an acceptance. An offer should be firm, not ambiguous. Okay? What do I mean? Leo boss, ukiamua unachomoka hapa na kadem. That offer must be firm. Tunaenda home. Sio ati wacha tutembee tu tuone penye life itatufikisha. It must be firm, a firm offer, not ambiguous. Yeah? They must know exactly what you're offering. And when I was your age, when I was still in the stage here, kutafutwa, let me say that, I once met this dude who told me, we should just be friends, no strings attached. I was like, Like me, I'm a sanguine, I have many friends. So I'm not looking for friends. Sasa kama si wewe tembea na Yesu. Tukutane mbinguni. You know, those are the ambiguous things, eh? When someone tells you, let's be friends, no strings attached, what for? By the way, wasichana hiyo ni free advice. Now I'm mentoring. Hakuna mambo ya friendships, no strings attached, eh? Either anataka relationship ama ataki na akue clear. Offers must be firm and clear, not ambiguous. Yeah? What am I offering? What am I offering? These duties may be explained further in the terms and conditions. Yeah? You can explain further in the terms and conditions, in obligations, who does what. But remember, the offer must be very firm. An offer doesn't technically exist until it is received by the other person. So if my offer bado tu iko kwa kichwa, it's not an offer. Until I offer. Legally, that's how we look at contracts. Was there an offer? Was it received by the other person? Yeah. You can't assume offers. You have to offer. You can't assume. Yes, Peter. The next thing we are going to is acceptance. Yeah. So when it's received, the offer can be accepted. It can be altered. Again, remember, si lazima. Okay? Unaweza ambia huyo dem twende. Atasema yes or no. Si ndio? Ama aseme to adjust, tupitie tao, tununue chipo. You can adjust the offer. You can alter it. You can revoke. You can terminate. Unaweza kataa pia. Unaweza kubali. If a counter offer is made, the original offer is terminated. That's how contracts are looked at. If I've offered this and the other person counters, makes a counter offer, it means the original offer is terminated. So we are now negotiating the counter offer. Niseme, Peter, come and take photos for me. Dakulipa 50K. Then useme, no, lipa 80. So the 50 offer is revoked. We are now talking about the 80. That's what I mean, yeah? We are now negotiating the counter offer. As long as there's a counter offer, the first offer is deemed to have been revoked. That is how the law looks at it. So if you're explaining the conversation, now say, they offered me 100K, then me I said 150. The judge automatically is at 150. He's thinking that's the offer now. Tulisha toka hiyo 100. An invitation to treat may be an offer. Okay. There is something we call an invitation to treat, which is used a lot in real estate. When someone is going to buy a house, that is different from an offer. That is like you're inviting someone to make an offer. That is usually different. But a contract offer, especially for copyright contracts, somebody must make a real offer. Yeah, offer what they're offering. Someone was saying they would like to know how their music would be used, for example, in films. Yeah, so you say, today I've met Peter, he does films, niko na haka ka song, you're offering. Why can't you use this in the whatever, and this is how we'll deal. That's the offer, yeah? Then now we are here, Peter, at acceptance. There must be acceptance. I can't just offer you something and assume you may accept. You have to accept. Somebody has to accept. It comes usually after the offer, of course. For valid acceptance to occur, the parties must agree to all of the contract's terms, either with the changes you have made or without changes or whatever. But you have agreed. You have to agree, yeah? You wait until all the recipients of the offer are mutually agreed. What do I mean? There may be still negotiation going back and forth. So you have to wait until mumekubaliana. Yeah? I may offer, you counter offer, I counter offer. So we're still going back and forth. For there to, if you misspell my name, let me tell you, a lawyer somewhere will just say, sijui pata ni nani, huyu client wangu ni Peter, just because of a misspell, yeah? They'll claim that it's somebody different. And that is why if you have documents that your names are not properly spelled, you will be asked to do an affidavit to show that this is still the same person. I have seen lots of people who maybe your name was misspelled in your school documents or in your ID or in your birth certificate. They are not tallying. You'll be asked all the time, get an affidavit to prove that this is the same person. So you must check that there's proper spelling, proper grammar. Why grammar? Because even a comma can change a meaning of something. Yeah? Where you place the comma gives another meaning. So you need to check proper spelling, proper grammar, restate the terms of your contract and receive a verbal acceptance. Place the acceptance statement at the beginning of the agreement. We will see a sample agreement, but usually you'll say, we have mutually agreed 1, 2, 3. That's the acceptance statement, yeah? State verbally what the parties need to do to accept the agreement. Yeah, so I'll tell you, to accept an agreement, even now, employment, whatever, they'll tell you, if you accept this offer, sign this and bring it back. So you need to state what someone needs to do to accept, then seek help from a lawyer that can guarantee everyone's acceptance. And again, I said, Copyright Board can give such services to creatives for free, yeah? But well, maybe nasema for free na mko na do. So you also have the option of finding an IP lawyer and paying. Umeona vile Peter amecheka, alikuwa nafikiria, to me I have money. Who said I need free services? Eh? Consideration, that's what the law calls it, consideration. But it means what? Money. That's why nimeweka hapo hiyo picture. To have a valid legal agreement, one party must exchange something of value with another party. Usually it is money we are exchanging, yeah? A contract may offer things like products, like protection, like property. You may say you're exchanging your car or your shamba or whatever. It's still okay. But it has to be something of value, yeah? Basically, the offer being made has to come with a price tag. It has to come with a price tag. You can't say, kuna contract ya kukupatia gift. That's not a contract. If I'm gifting you something, I just gift you. Yeah? The moment it's a contract we are signing, there needs to be an exchange of something of value, money or something else. The law calls this one a meeting of the minds. Yeah? At this stage, both parties have recognized the contract and both have agreed to enter into its obligations. The meeting of the minds may also be referred to as a genuine agreement, mutual agreement, and you will see in contracts sometimes they use the word mutually agreed, mutual, yeah? Mutual agreement. There must be a meeting of the minds. If we are talking at cross purposes or we understood the things differently, then there is no meeting of the minds. Okay? What's your name? Ephantus. Umeva pink. My daughter told me pink ni wasichana. My son usually chases me away with pink things. I need to take a photo with you. Nimwambie unaona huyu amevaa pink. Ndio? Fantas, ukikutana na mrembo hapa leo, wewe unamwambia leo acha tuende home. Tupike, tukule, to relax. That's all you say. So in your mind, umepata mtu wa kukupikia, kukuoshea nyumba. But in her mind, amepata husband. Is there a meeting of the minds? What do you think? But you can assume, why would a guy tell you tuende kwangu tupike tukule? Maybe you've made the right assumption. Yeah? Sleepover, eh? Mtu amekuinvite sleepover. Is it safe to assume amenioa? Is it safe? Anakuinvite sleepover ya nini? I'm there to assess the offer. My point is this. Whatever he has in mind when he's inviting that girl for sleepover, and whatever she has in mind when she's going, must be the same. They must agree. Otherwise, the law will say there was no meeting of the minds. Ulifikiria umepata mboch, huyo akafikiria amepata bwana. There is no meeting of the minds. You both must come to a meeting of the minds. I know what you want, and you know what I want. That's why I tell young girls, we don't assume relationships. Niliona huku kwa online ati watu wengine munajipatanga tu kwa relationship ya wenyewe. Situationship. We don't assume. This is what contracts are saying. No assumptions. No assumptions. You must agree. You know what the person is saying. And you know what they want. Nakwambia you guys, dating a lawyer ni ngumu. Mimi nilikuwa nauliza mse unasema, unatakaje? Umenipenda ama hujanipenda? It's that simple. With the diagrams, unasemaje? Ukiona mtu ameoa wakili, you need to buy them a soda. Hizi ndio maswali unaulizwa. What do you mean? What do you mean? What do you want? For how long? Temporary or is it? Yeah. But with contracts, you have to be serious. There must be a meeting of the minds. Chenye umefikiria, ndio chenye amefikiria. No assumptions. That's what the law means by saying there must be a meeting of the minds. Si unaona hapo the goats are meeting. Niliona hii kwa video ingine ya bullfighting. Hivi ndio hiyo ufanywa, bullfighting. Competency and capacity. That photo I've put there, munaona nani? Mrembo, anafanya? Akoma vitu, akoma things. You can't sign a contract with a drunk person, okay? Because at that point, their mind is compromised. You can't go to Mathare and sign a contract with somebody who is in for mental illness. They don't have capacity. You can't sign a contract with someone who is underage, less than 18. Yeah? So before you enter into a contract, the parties must have the capacity to do that. If they're always high, you have to find a way to wait for them to be sober. Oh, you said artists are always high. You can't, guys, don't sign contracts when you're high, please. Sailo maamuka tu, maybe you sign sayo. You need to sign when you have capacity. Yeah? When you have your mental capacity to be there. Otherwise, it will be null and void. Examples of this include a person signing a document when they're under some undue influence or unsound mind. Yeah? Or even you have a gun to your head. That is undue influence. You cannot sign a contract. That contract will not be valid. Yeah? The moment you show that I was being influenced by something beyond my control, then you can nullify that. I have seen, like, especially in the US and other places, like when they force people to sign confessions at the police station after torture, you know, you can nullify that in court because you didn't have the capacity. You've been starved for 3 days, ujapewa maji, ujalala. At that point, umefika tu ile point here, sign and go. Yeah, you can nullify such whatever confession. So somebody needs to have capacity. Legality. The whole point of contract law is to protect others from contracts that could be considered unconstitutional or illegal. For example, entering into a contract with minors or making contracts to break the law. You've entered into a contract with this jamaa aende kuvunja nyumba ya wenyewe akuibie kitu. That contract is illegal, yeah? Because stealing is illegal. Entering into a contract with somebody to murder, that is not allowed, yeah? So you cannot enter into a contract to do something illegal. Always use a written contract and include a dispute resolution clause also, yeah? In case you have a dispute, how do you resolve that dispute? If you don't have a dispute resolution clause, usually you'll just go to court, yeah? But you need to have that clause. Either say, in case of a dispute, we'll go to court, or we'll find an arbitrator, or we'll find a mediator. You can say things like that in your contract, yeah? But court is always an option. That one is open, always an option. So some of the contracts we have, especially in the area for creatives, is this split sheet agreements. This is a written agreement that identifies each contributor to a song, for example, and establishes ownership and percentages amongst those people. The agreed percentages determine how much each contributor will receive for royalties, yeah? So I know this is usually an emotive subject for creatives. Collective management. Collective management idea, yeah, was born in France the first time. This guy sat into a cafe, let's say somewhere like at Cafe Ama Java, and he was eating and doing his thing. Then there was a live band, and the live band was playing one of his songs. So they play his song, and he's like, wow, he's jazzed. These guys are playing my song. Then akiamka anachapwa na bill fulani, unajua vile umeikula rent, umeenda mahali umekula lakini the amount ni rent yako, hivyo. Then he said, thinking, now wajanilipa, see, they have been here playing my song. They have not paid me. So that's how the revolution started. He called other musicians. He actually took the matter to court and sued the restaurant, and they were asked to pay for public performance of his song. And so he came together with other musicians, and they started an organization. The role of the organization, CMOs, are usually to monitor the use of your work. Because in the absence of that, it means utembe kwa all the restaurants, all establishments listening. Are they playing my song? Then you sit down and listen to all radio stations, all TV stations, if they're playing you. Then you ride in all matatus in Kenya, listening if they'll play your song. Then you go to all businesses. See, utafika 100 years kama hujamaliza. That's not possible. So the idea is that because you can't do that by yourself, and then he does that and he does that, you come together, you form an institution which is supposed to do that. Monitor the use of your work. Go out and negotiate licenses with the users. Issue licenses, receive the money for use of your work. Na hapa ndio kizungumkuti iko. Distribute back. Okay? So that's the idea, and that is how it would work in an ideal situation. It doesn't always work like that in Kenya. But I know out there it does work. Yeah? It does work, and people earn from royalties. Yeah? So now, if you're going to earn from this song, let me give an example of a song, because that's why we use split sheets a lot. Publisher, author, usually it's kind of simple agreement that they know how to do it, yeah? With publishers and authors, for example, if I'm publishing a book, I go with a manuscript. I'll tell a publisher, niko na hii manuscript, can you publish? They look at it, they say, sawa. Then they tell you, we charge 500K. I'm like, boss, sina hiyo pesa. Then the publisher decides, okay, let me publish you. I'll recoup this money when we sell the book. That tilts the percentages. Sindio? Because then the publisher will get a higher percentage to be able to recoup what they put in. Because kuna design, kuna editorial, kuna printing, kuna marketing and distribution. So for them to recoup that, they have to get a larger percentage. Yeah? Music is the same. I go to a producer and I have this song. It sounds nice and all. I love they say, like one producer I know told me they charge like 14K per song. There's 8K for studio time, 1K for every BGV. If you want alto, soprano, nini, wanakuwekea. So the whole thing, let's say one song I've used 20-something K. So I have the money, I pay. In that case, also percentages tilt. If royalties were to be paid, I get the lion's share. But in Ikianda Sinado, but they've listened to the song and said, this one could be a hit. Then they say, let's put in the money to produce, we will recoup. Again, the percentages will tilt. They'll get more, yeah? But also remember, in a song, the composer has a right, sindio? The author has a right, yeah? The performer has a right. The producer also has a right. So you still need to govern these relationships of these people. How do they get their share of that money whenever that money is used? And that's the reason why in Kenya you have the 3 CMOs. The one would represent the author-composer. Then there's one for producers and there's one for performers. And they have their own arrangement of how they're supposed to share that money. But usually the law says the first owner of copyright is author-composer. Unless you are employed as a songwriter under a contract of employment, na kazi yako ni kuandika tu wimbo unaenda. But the person who sits down to put the lyrics and the tune to the song owns the song, the first owner. But ukitoa kazi ya producer, is the song same? No? So they also have a related right. That's why copyright is called copyright and related rights. And then the performer may be a different person, they may not be. Yeah? So again, the performer needs to get their share of it. So with a split sheet agreement, it will tell you how many people have contributed to this song. Especially if you have things like collabos. I know there are collabos where I'll say, I like Jemima's voice. I've written a song, kuja unieke, voice yako kwa verse 2. But I'm the one who wrote the song. But there's another collabo where you co-write. I write a verse, you write a verse, you have a significant contribution. So all those dynamics need to be agreed upon in the split sheet agreement. Because when money starts coming, hapo ndio kunakuwa na shida. So they are necessary for every song you write with collaborators, yeah? They ensure everyone involved in the creative process is either credited but also paid whenever they need to be paid, yeah? It's also important to note that split sheets are not a copyright agreement. A copyright agreement is ownership. You're talking about ownership of copyright. A split sheet, you're talking about you have contributed into this. You may not own, but you contributed. How much do you get? How much do you get? How much do you get? That's what we're talking about, yeah? So a basic split sheet agreement should include the date, of course. Hey, by the way, all your contracts need to include a date. Remember that. But also, the other way we sign contracts, you sign on top of every page. Because if I go and change the top page, no uli sign nyuma peke. Peter hujai fanya hivyo. Aha. Wewe utashikwa siku moja, utakuja kunitafuta. You sign on top of every page so that the person cannot change. Because nowadays you type everything. So mtu anaweza enda kuchange juu. So you sign on top, at the bottom hapo chini, every page. Then there's an execution page, yeah? So you must have a date. If it is a song, you must have the title of the song that you're talking about. The legal names of all contributing writers involved. Tusahau stage name kidogo kwa contracts, please. Role in the song creation. If it's the producer, if it's the songwriter, if it's the this, you write. Ownership percentage of each contributor. So what percentages have you agreed upon? Tumeagree, wewe utapata ngapi? Wewe ngapi? Mimi ngapi? It has to be in the contract, yeah? We can't assume. Specific contribution. Was it the lyrics? Was it the melody? Was it the beats? What has this person contributed specifically? The record label, if it is there. The performing rights organization, if available, that means CMO, yeah? Out there they call them performing rights organization. The publishing company, if it's different, and if you have a music publisher, you also need to have that. Mailing addresses, contact information, and then signature. Because if you don't sign, it is not a valid contract, yeah? And I've just told you the trick on how we sign contracts so that people cannot change the contracts, yeah? So as a creator, it's essential to understand the value of your work, especially before it's published. You know, I usually say intellectual property is just what those words mean, intellect and property. But when we think of property, we think of your car, your house, your shamba. But creatives are yet to reach a point where we think of our film, our book, our script as property. Ama unangoja ufike John Grisham, sold in 1 billion. Juzi niliona one of the books sold in 1 billion copies. Hata ya Daniel Steele. I saw sold in 1 billion copies. Nikajiuliza, how much money did she make from it? She may not have thought about this when she was starting, right? Pardon? No, I saw it in the bookshop. I stopped reading. Hata sina time. Hiyo ndio shida. I stopped reading them. But I used to love reading John Grisham and Daniel Steele. And John Grisham used to be a lawyer. But I guess he's made so much more from writing than law. Yeah, so I'm imagining the first book he wrote. Hakufikiria hivyo. Hakufikiria ni property. But sahi, atakwambia a bestseller, I've sold 1 billion copies. Akiingia kwa bank atapewa loan. Peter, ukienda kwa bank useme mimi ni msanii, unafikiria watasema? Let's start recalibrating our thinking about our creative works. Think about it as your property. And then think about it like it could be big. And when it is big, lay the foundation before. Have your contracts in place, have everything. Actually, with creatives, shida ukuja when it hits. Because when it's still, nobody cares. But when it hits and it's making money, then the problems begin. Then you realize we never signed a contract. We never agreed this. We never talked about this. I think the semester I was teaching about music last semester, music agreements and licensing. One of the things we looked at were band agreements. Why bands need to have agreements? You know, even groups, music groups, then they never do. Most of them never do. I know one very famous old band in Kenya. Wamesumbuana na wakasumbuana na spouses of their founder members who died. Yeah, and basically they never had any agreements. And in fact, it's until one of the spouses came with handwritten paper to Kekobo saying, my husband wrote this song. And it was just, by the way, your paper name is there. It was just that it had been kept. But how would you know? It would just be your word against mine, yeah? So it's good to put our ducks in a row from the beginning, before the problems come. Also, be proactive and take control of the conversation by using split sheets to secure your fair share. So you're taking control from the beginning, yeah? To may agree, these are the split sheets. Pesa ikipatikana, this is how people are being paid. Moreover, start negotiating splits early to avoid disputes. And if you're having trouble coming up with a good agreement, get a lawyer, get a lawyer, get a lawyer. Again, Kekobo has lawyers. We all have masters in IP, and we can give you the services for free. Peter najua uko na do, lakini naambia for free. When you wanna do for free, kuja tu, just come and say, I want a lawyer to help me read this contract. I want a lawyer to help me to advise me. That's all you're being told to do. Come for the services, yeah? Yes, you had a question.
And then on acceptance, I don't know, like who should sign first? they were an offering, or ideally they'll give you to sign, then back to them. So what if
We should sign what first?
the contract?
No, it doesn't matter. You're mutually agreeing. And sometimes you're together by the time
like
you have
both
agreed.
have to sign, isn't it?
Yes.
So that's what I was saying. Like myself, okay, like code of conduct agreement, for example, for the production of something. So you're given that document, you sign maybe on Monday, then them they sign on Friday. So is it that both parties, it begins to be enforced Friday when
Oh,
signed?
yes. It
or-
begins to be enforced when both parties have signed, not one.
So if only me has signed
No,
and
it's
they
not.
haven't,
It's
it's
not.
still
It's still not yet
consideration
a contract.
stage.
Yes.
Okay.
You have to sign, I have to sign. Then we have mutually showed our agreement on paper. Because kama mtu haja sign, bado and you don't know if they'll sign. Yeah, but now the date of commencement of the contract, so to speak, will be the date the second person signs. Yeah.
Thank you very much.
Consideration part, there's this thing when, especially in producer-artist relationships, for example, when an artist is leasing a beat from a producer from another country, and they don't sign physically, and maybe there's this clause saying that we've sent the contract via the email, and in the next like 3 days, if you've not gotten back, it's an assumption that like that can act as a signature. Is it true?
No. You can challenge that one in court. Because now you have e-signatures, yeah?
Yeah.
So just the time that you did not respond cannot act as a signature. Yeah. It can be assumed. In the law we say silence means consent. So you can assume umekubali, but for a contract to be valid, you must sign it.
Okay.
You can't just assume umekubali ndio, but you have to sign a contract. But if they assume that, you can challenge such a contract in court. A contract to be valid, you must sign. Yeah. But that whatever you're talking about, it means that they assume umekubali the terms. Yeah. But hata kama umekubali, you must sign a contract. You cannot execute a contract that is not signed. Yeah. I need help with this a bit. Yeah. There's a question here.
Hi, thank you very much for the information. Just a quick question. Is there a way we can get these materials, or is there a place that you'd recommend we get some of these materials for reference in future?
Okay, I can share my PowerPoint if you
Please.
want the information.
Yes, please.
Yeah, but you're not supposed to misuse them, eh?
It's under copyright.
It's my copyright. Okay. I wanted to open one of these sample contracts. Yes, there's another question. Yes?
My question is, so before a contract ikuwe fully signed, sasa hapa tutakuwa na documents kaa ngapi hivi? Tuseme documents kaa 3 ya offer, acceptance, agreement, ama it's all combined into one?
Offer, acceptance, that could be even verbal. Yeah? But the contract, the agreement itself, finally, to may agree, that must be written.
So the rest can just be verbal.
Yeah,
Tuseme
it could
kama
be
offer.
discussions, meetings, you're in a meeting, you discussed, we
So
offered
you don't
this.
necessarily need to offer a document.
No, the offer is not a document. It's not necessarily a document. Unless we are not together and I sent akutumia email. And this is my offer, and you counter, and we keep going back and forth on email. But the final document that you need is the contract. Yeah, of what you have finally agreed upon.
Okay, thanks.
I need some help with this. I don't know what's happening. Yeah.
Hello.
Yeah. Hi.
I have some few questions.
Few ni ngapi?
Kama 2-3. So the first one is about the free lawyers. Do you mind telling us how to get them? Like, if I want that lawyer, that legal aid from Kekobo,
Yeah.
where do I go, or what number do I call,
okay.
or which email do I send?
Yeah, you can either come to the office, which I always tell people it's easier and better, because when you're speaking to the lawyer, they'll get you well, they'll understand you, they'll ask you certain questions, then they're able to help you. But if you write an email, what I receive on my desk is an email inquiry, so I will interpret it the way I interpret, and then I respond. So I usually encourage that if you're in Nairobi, you just come if you can.
Where are the
To
offices?
Kekobo. Our offices are at NHIF building. It's now called SHA building. At community, opposite the library, on the 5th floor. But we also have a website. We are on X, we are on LinkedIn, on Facebook, on TikTok. Kenya Copyright Board, Kenya Copyright Board. You can find our contacts. You can call also. If you can call and get through and ask to speak to a legal person, it can work, yeah. But I always encourage, if you can, it would be better to come. You meet someone one-on-one, they ask you the questions they want to ask you so that they're able to help you properly.
And is it just, if it's a contract,
Yeah.
the legal aid comes if it's just about
Copyright.
copyright
Yes,
only,
usilete
or-
mambo ya shamba, usilete mambo ya bibi yako alikuacha, please.
Yeah.
Copyright.
Good.
Copyright.
Good to know. My second...
Huyo atakuja aseme wakili ya quick one, nilikuwa na shamba. No.
Thank you. A second question. I'm sorry if it might take you back.
Yeah.
Because this is the first session I'm attending.
Okay.
There's something you said about visually impaired, taking like I'm a script writer. So if they take my script and change it into Braille, that they don't have to get permission from me. So my question is, what if they change it into Braille and they use it to produce money? Maybe they earn something from it. Maybe the Braille one becomes more better than mine, and you know, you hit and people are like, there's this Braille script
that's better.
Yeah, and it starts generating
Well, if you
money.
think about it, how many people consume Braille? It's them still. Yeah?
Yeah,
Yeah.
but you know, art is unique. And the reason why I'm saying that is because it can become so fascinating for someone to see, even those who don't have visual
impairment.
For them to see a Braille script. You know,
Okay,
it's like
Yeah.
it's like when the museum uone kiatu ya Dedan Kimathi. You are like, wow. You see? Are you getting the sense?
No,
Like-
I'm kind of getting you. What I'm saying was that if I buy something for Braille, is to see. It probably fascinates me. But it won't be of use to me because I cannot read Braille. So the whole idea
But there will
for
be
giving...
other blind people who will read it.
Yes, that's what I'm saying.
And they might pay
The
for them to
people
get
who
it.
benefit at the end of the day are other blind people. And that is the whole idea, to benefit them. Because the accessibility for them has been an issue. Because if I'm not blind, and not many people do Braille, do things in Braille. Because they're not blind and they don't think about them. If I was writing a script, kama wewe, utaanza kuandika in Braille, you'll write your script because you don't consume Braille and you may not think about them. So the whole idea of this treaty was to make works accessible for visually impaired people. And so for the law is saying if it is them consuming, it is okay. So the exception is there in the law. There's a treaty, it's called the Marrakesh Treaty for visually impaired persons and people with print disabilities. And it says, so now, then it is in our law. They can use works without paying, without permission for themselves. Not commercially, not at their producing and selling and what, not commercially, for their use, for their consumption.
Oh,
Yeah,
that
not for
makes
commercial
sense.
purposes. For their consumption, for their use, to aid them in learning, to do whatever, yeah. But not ati mse anapiga biashara, no. With copyright, the whole idea of copyright is that if you're gaining commercially from something, then you need to ask for permission or pay, yeah?
Okay.
Yeah.
The context, I don't know, because profit-wise, the consumption is the sales. So is this translation before sales? Like, I have a book, this person wants to maybe read the epilogue, which is something anyone can read. So a braille epilogue is fine. But this is a book in a bookshop. They borrow it, translate to braille, return the readable copy, keep the braille for themselves. They haven't purchased the works. Is that what is envisioned in that treaty, or it's just about giving them understanding?
No, the
Of what the
idea
work
is
is.
that even you who is not visually impaired, you can buy a book and photocopy it and put it in your house, or you can share an ebook. You always do that. With copyright, they say one of the exceptions is for private use. If I buy a book for use in my house, that's allowed. I bought the book, I use it in my house. The moment I begin to distribute this book to others, that's a problem. Why? Because if I come and give you that book, I recommend it, then I give you all for free. You want to buy? So the person will not earn from it. The idea of private use is allowed. And that's why they say, even with music, if I am in my car and I am playing music in my car, it's okay. The moment I go commercial, I'm in a matatu, that's a problem. Because the people entering the matatu pay. You get? So the whole issue of commercial use comes into infringement. Am I doing this thing for commercial gain? But for private use, you're allowed to do that. Even you who is not blind, you can buy a book, put it in your house. But the moment you decide, nimetoa kopi 10, wacha niuze, that's a problem. Of course. But usually the argument has been wherever premises they play at has paid for the license. Because you'll find most of them will play in a club. And the club has already paid for the license. And you know, actually, this, I know it will be a debate now, wanaweza kasirika, but what DJs do actually, they mutilate the work. Because you're not supposed to change somebody's work. How would you feel if I take your script and then I badilisha it kidogo to suit me, to suit my story? You wouldn't be happy, huh? Yeah, because you told your story in your own way. So if I want to use it, ask for permission and use it like that. It's like I decide, leo sijakuja na gari. I say, Peter, nipe gari yako, nikimbie nayo mahali. Then I come back with it. It was white, it's now blue. Because me, I don't like being seen in a white car. Me spendi gari ya white, so nilieka tu rangi ya blue. You see how it works? That's your property. So if someone changes it, it's a problem. It's a problem. Yeah, so this is a sample of a contract. So this is a contract for writing lyrics, yeah? So you can see here, you have the agreement is made this day of this, so you need a date. Sindio? Then between so and so, and you can see it's been put there nicely, postal address, whatever. In fact, nowadays you will say between Peter Kawa of ID number, blah, blah, blah. Because PO Box siku hizi hata hakuna watu wako nayo, sindio? And then you say probably the composer and the author. See, we defined the difference last time. We know what it is, yeah? The person writing the lyrics, the person putting the tune, yeah? So you can see here they're saying, whereas it is hereby agreed as follows. Okay? We have agreed. Like this one says, this contract supersedes all previous agreements. Oh yeah, by the way, if I had a contract with you, Peter, and then we sign a new contract next week. The new contract trashes the old contract, okay? So if you have an existing contract and you sign another contract on the same subject, it then means the newer contract is what is valid, yeah? You can look at B. It is saying the parties warrant and represent that they have power and authority to enter into and perform. You may sign a contract with a company, no, may sign a cleaner. Do they have the power and authority to sign? That contract will be nullified. So you need to make sure if it's an organization, you're also signing with the right people who have the capacity to sign that contract, yeah? Again, number C, we are seeing parties desire to enter into this contract. Unataka. This is the voluntary we were talking about. Umetaka kuingia your contract. Ujalazimishwa. Yeah. So the commencement here, inasema, the commencement of this contract shall be upon signing by the parties. Sio mmoja, by the parties. So ownership here, the parties have agreed the lyrics will be jointly owned 50-50 or whatever you have agreed. So you must put an ownership clause, eh? Who owns what? Then consideration ni mambo ya pesa. This is the amount that I'm going to get. Sometimes with consideration, you can also say whether you're paying in installments, whether you'll be paying royalties. Like with book publishing, I know they usually sign to be paid royalties every year at a certain percentage, yeah? So that's the part you'll put for consideration. This one has even a royalties clause. Adaptations, the composer or author or both shall not be entitled to authorize any person to do adaptations. You can agree that or not, or translations, yeah? You can put such things in there. Then you have the obligations of the author, the obligations of the composer. You need to put an indemnity clause. An indemnity clause means that you're indemnifying that person in case issues arise, okay? So for example, if I have entered into a contract, if I have entered into a contract to sell you my car, na kumbe, I had also sold somebody else that car. Indemnity clause will protect you from having an issue with that person. That person cannot sue you. They have no relationship with you. Okay? You deal with me. I have dealt with them. See, you've seen those kind of people. You offer this to this one, then you come and offer to this one. And we've probably taken money from both. So indemnity clause is just saying, me, I'm indemnifying you from any other to shenanigans I might have huku nje. I'm only dealing with you and you can sue me. Yeah? So that he cannot come to sue you ati mimi ndio nilikuwa nimenunua hii gari, no. So that indemnity clause is always very important to put in a contract. Then of course confidentiality, amendments. I said contract should not be cast in stone. You should give room for amendments, yeah? Sales and transfers, whenever you sell that song or whatever or transfer it, what happens, yeah? Duration of the contract, contracts usually would have a duration. So that needs to be there. With music contracts, you must talk about territory, yeah? Because someone can give you permission to deal in Kenya or in East Africa and not in Europe. So you also have to talk about which territory are we talking about. This force majeure is another very important clause to put. This is the clause that you put to say that you will not hold me accountable to perform that contract when there are things beyond my control. Actually, in the law, we call it acts of God. So now I have a contract with you to do something. Then COVID hits and there's a shutdown. I have a contract to come and perform in Kisumu. Then kuna COVID and there's lockdown. So I really can't come. It is out of my control. Or an earthquake happened. It is out of my control, yeah? There's nothing I could do. So this clause usually would protect people whenever acts of God happen or certain things happen that make you not able to perform the contract. You cannot be forced to perform the contract, okay? So that's usually what it means, and that's usually why it's there. Yes, Peter? Yes. So now the trick will now be to agree with the person. Do you refund the money? Do I refund a percentage of it? Because let's say I am coming to perform, and it's an earthquake. There's actually nowhere to pass. But ulikuwa umenilipa. Ulikuwa umenilipa some money. You know, actually, it's both of us losing. Because I'm losing the income, but you're also losing the money you had already given. But then what happened? There was an earthquake, and there's nowhere even to pass to come. So you would have to renegotiate and say, do you refund a little? Do I do what? So that would be a different conversation. But force majeure will protect you from acts of God. That's what they're called. Things beyond your control that you could not control. Yes. No, that's not an act of God. You can't take that to be something beyond your control. You see, if I'm planning an event, I will have to think about those things. What if it rains? What if it's hot? Whatever. So that sounds more like neglect than, because now you'll have to go back to the contract. What were the obligations of the person contracting the artist? I needed to provide a proper stage. I needed to provide a proper premise. Did I provide or not? So those are provisions of the contract. That's why you have obligations of the artist you're calling and your obligations. I am calling you to perform in an event, then you reach there and find there are no people. But it was my obligation to provide the people. I have not kept part of my bargain, right? Yeah. Then, of course, dispute settlement is very key. It must be there. This one for notices, usually you will just say how to notify the other person of any change or whatever, even a change of address. Yeah. I want to notify you. I can't just post on Facebook. By the way, take note, kila mtu mwenye mesign contract na mimi, jinangu ilibadilika, I'm now Mrs. Wata. No. We need to agree. If I need to notify you of any change, I send you a letter, or I do this or this. Termination clause must be there. I have been told before in trainings by some artists they've signed contracts with no termination clause. I'm like, huh? How now? Termination clause must be there. The contract must provide a way of you getting out of it. They are not cast in stone, eh? They must be there. If they lack, there's a problem with that contract. You can actually challenge the validity of that contract. Yeah, but termination clause must be there. Then the governing law, that one must be there. Because then when something goes wrong, and then you come and say, me, I'm Ugandan, so I'm going to sue you in Uganda. The governing law must be there. Are we signing the contract in Kenya? What is the governing law? It must be in one territory, yeah? And then, of course, the signature part, you will have the signatures. Either you can get a lawyer, commission of oaths, or you can get witnesses to sign for you, yeah? You have a witness, they have a witness. So I can even share, these are from ARIPO, the African Regional Intellectual Property Office, and they usually agree that you can have this. So I can share this document. This one is a publishing one. You can look at it later in detail, the music people. This is for music publishing, yeah? Not books, yeah. Good, so let's do infringement because, it's 1:30, yeah. Yes.
Please use the microphone.
The part for jurisdiction, I have seen some contracts talking
You mean
about
territory?
Yeah, territory. Territory. I've seen some contracts saying throughout the universe. What could be the intention of such a clause in a contract?
It probably could mean worldwide. Probably that's another name to mean worldwide.
Couldn't they just say worldwide instead of universe?
My friend, some of us come from places we need to use big words. So you can't force us to use small words.
I thought it suggests that there's a possibility of other universes out there that they're playing the music in.
Now, you may have missed that part. I talked about being clear and providing no ambiguities, yeah? Contracts must be clear. Because whenever you provide ambiguities, then it's up to the interpretation of the judge. who, if you find them in a good or bad mood, they're still a human being. Contracts must be clear. Don't use words that are not clear. Contracts must be clear.
Just to follow up on that, it's not related, but I missed it on the other time you were taking questions on it. For the part of the PROs, what is the mechanism, for example, if you want, how would you ascertain what you're entitled to once you've registered to the PRO? For example, if the song is playing on radio, most of the artists, especially here, they complain that they get 2,500 per year.
I know, yeah.
So how would you ascertain what you're entitled to?
The ideal situation, again, me, I'm not talking about Kenya, because Kenya, ideal ni kitu ingine. The ideal situation should be this, and this is how it works out there. They have software for monitoring. Whenever your song is played online, on media houses, they have. Initially here, the CMOs were trying to get media houses to give them logs. But as far as I know, I don't think there's any media house that has ever given logs to them. But initially they were trying to get media houses to give them logs so that if Citizen gives you their logs for the month, then unajua Peter was played 3 times this month, next time he was played 5, so you are able to calculate from that. And that is what they call scientific distribution. So that's the ideal distribution they should do, because they should know exactly how much you will earn. Now for them, because they don't know, they don't have those nitty-gritties, they do general distribution. Although recently, I saw one of them saying that they did scientific distribution. I have not interrogated how they did that. So what they do is general. So they say, we have 10M to distribute. We have 10,000 members. Divide. Kila mtu apate share yake. So that's how they have done it in the past, yeah? General distribution. But the ideal situation should be scientific, whereby you're earning exactly what you deserve, because what makes you money is the play and the use of your work, and not just msanii. What makes you money, or supposed to make you money, is how much your work is used. And that's the reason why you have had complaints before, because I'm famous. My music is played a lot. How am I getting the same as you, who we've never heard about, yeah? So I think that has been the issue for them in terms of distribution. But the other issue has been the copyright regulations have given percentage of how much they should at least distribute, which is 70%. But usually, practically, they end up distributing maybe even 10. And they'll say they use a lot to do the work, to collect. So if, for example, you tell me, Peter owes me a K, enda unichukulie. Okay? So I'm the CMO, you're the artist, that's the user. You say, Peter owes me a K. Go bring that K. Then I go and come back and tell you, kufika kwa Peter nimetumia 900. Shika so. Does it make sense? Would you have sent me if you knew the transport is 900? No. But if I came back and say, nyewe, I used 2 soak. Shika 800. That might make more sense. So that's the dynamics that we have struggled with in this country about distribution. But that's a whole monster conversation that I know even the government is now involved in terms of resetting things, yeah? I know in December 12th, the president gave a directive that Kekobo should work with other stakeholders to make sure there's a system in place that is able to collect and pay people what they deserve. Yeah, so that conversation is still ongoing behind the scenes. Yeah. So that's the problem we have had. And that's why you have had complaints. But otherwise, if the 70 was being distributed, I'm sure we'd have a little less complaints than, yeah.
Oh, still on that.
Yeah.
Today I was heavy on that, but you've answered part of the questions, because I was thinking Kekobo is the law-making entity,
Yeah.
and I believe the CMOs, when you sign the treaties and whatever, they have to follow that, right?
Okay, no, not entirely. CMOs are private companies. Which, in fact, most of the time I tell creatives, hata nyinyi mnajilet down. Because a CMO is registered as a company limited by guarantee with members. So ideally, the members should be in control. Where you decide, board is not working for us, we need an AGM, we need to change these people. You decide management is not working for us. The only problem is that the way they are structured now, it's like there's nothing the artist can do to change that. Why? The management will control, they are not calling AGMs. So utakuwa na AGM, now even when they call, some artists don't show. So then you don't have the numbers to show, because if one CMO is telling us we have 15,000 members, imagine if just 10,000 showed up for an AGM and decided we are changing this board. But I think that's where the control comes. That's where they have the control. They know how they work the mechanisms of how they do the AGMs, who comes, who is able to be elected, you know. And then now you really, as an artist, lose that. You've ceded that ground. You've lost that power to vote and choose who you want. And then there's management also. How governance works, boards govern institutions. So boards employ management. Mulisikia sometime back tukiambiwa mambo ya state capture. Boards manage, they're supposed to employ management and manage them. So that if management is not working for us, the board can sack you. But most of our organizations here, it seems like the management is in control more than the board. And so those dynamics are different. Now, we have an obligation in terms of to supervise and license them, but they're still private institutions owned by the members. So we only do what the Act allows us to do. And that's why in 2019, actually we had so many court cases about control. You're overstepping your mandate. You want to control us. Then where do you get that mandate? And in our Act, it only said license and supervise. What is that? It could be anything, yeah? So when we amended the Act, we made provisions to say we can do a forensic audit. We can have a say in who is on your board in terms of qualification. I mean, there's lots in the Act now that we can do a bit. But remember, we are still tied at, these are still private organizations, supposed to be controlled by members, but it doesn't work that way.
Oh, yeah, and again, the thing, I'm not trying to tear the artists, but sometimes it's overwhelming, especially in recent times, where there's MCSK, this PRISC, again, this a combination of MCSK and I don't know, PRIVASC, and then again, you hear somebody like Musioka has started like a producer, whatever, and again, now you don't understand that if a restaurant is paying for that license, how is this money again distributed to a lot of CMOs? You understand?
Yeah, so what was happening before, like I enumerated the different rights. You have an author, composer, performer, producer. They all have a right to receive something. So these institutions, organizations represent these people. So initially, that was the complaint. People kept coming and saying, "Mi nimelipa PRISC, then nimelipa MCSK, aren't you taxing me many times?" So we said, you see, the lay person who is the user out there doesn't understand all this demarcation of rights, mechanical rights, I don't know what, public performance, ajui. Anataka kama analipia copyright nilipe once. So that is how we came to the point of saying, guys, collect together. Alafu msikizane uko, how you will split. So they actually have a split agreement where I think MCSK gets 50-something%, because that's the author-composer, the others 20-something, something like that, yeah? So they have an agreement between them. But we insisted then, mukuje pamoja, so you pay one license for copyright, malizana. Then nyinyi watatu mwende kujipanga vile mta split your pesa between them, between yourselves, and how you now end up distributing to your people. So that's what happened. They used to collect together. But now the problem is they have their own issues. They have their own fights. So that's why you keep seeing all these different issues, because they have their own fights within themselves. But our insistence and recommendation was they collect together. And that's why there's a time the license had the three. They had to collect together. Because the lay person, the user, ajui hizi vitu unaniambia, mechanical rights, sijui public performance, nini. Me, I own a restaurant or a bar. I don't know those things. I just want to pay mara moja na nisahau. Yeah, so that was the idea behind asking them to collect together.
Okay. And last question.
Mm.
I had said earlier about our policy making in this nation. Is it going with times? Like now we have AI. Like recently, US said AI works cannot be copyrighted. So when it comes to Kenya, and we as artists incorporate part of the AI in our works, how do we go about that when it comes to copyright?
The conversation about AI is still out there, even globally, even at the World Intellectual Property Organization, yeah? And the problem for copyright and even patents with AI is that for patent, an inventor is a person. For copyright, an author is a person, a natural person or a legal person. So the conversation has been, when you're talking about AI, can AI be construed to be a person? And can you grant rights to AI? Because copyright is granting rights to an inventor, a creator, an author, a songwriter. So can you grant those rights to an AI? But we don't even have a law on AI yet, even internationally. But I think recently the ICT ministry have come up with an AI policy, which I haven't read it well, but I think it's supposed to start to push some of these conversations. But as far as copyright law is concerned, AI and copyright, bado hakuna decision. Are you granting rights to is AI a person? Is AI a legal person or a natural person? Because right now, copyright recognizes a natural person and a legal person. And even patents recognizes an inventor as a person. Yeah. Yes.
Mine is related to that, but it also has parallels. So for me, I think AI is like a field. You know, you can't tax air, you can't copyright air, but we all move in this space and all that. Land, is tangible. The air may not be. Though there's also in property whereby you can also ask about space above. So one, I want to go back to that thing of cover songs, because I feel if I add AI and I took your original image to make your photo, there is a foundation from you. The same way you wrote the song, but here I came to produce, add beats, perform, you know. So I feel, and as copyright board, that original works still have their persona. The same way, you can't take a picture of me and then go putting it all around. And you see that picture, I can edit, I can add color, make it black and white. So I feel AI is like edit of sort. Or maybe it's the software and coding of AI that then can be, if I'm able to, because like right now we are having OpenAI competing with Deep AI. You know, those are entities and they've produced a work, they've cracked a code and whatnot.
But I was in a meeting some time ago about AI, and there was a script writer who said he's learning to use it to write scripts. And what I understood from him is that it's not just machine imeka hapo ikaanza kuandika wimbo. There still has to be a person feeding
Exactly.
information
There's a labor.
into it. Okay? There still has to be a person feeding information. So he said for him, he uses AI as a means to do his work and doesn't see it quite as competing with him. The bit about copyright is creativity. There's the creativity, originality, and the grant of the right to a natural person. So you can't divorce that from copyright.
Yeah, that's why I was
Creativity,
saying
originality is, okay, I'm sitting down and just making up a song and I make it up. It's not, I'm just going to a machine and saying, write a song about love, and the song comes. There has to be an element of creativity when it comes to copyright. And creativity ni kukaa kujitengenezea. Hata ukitengeneza kitu yenye ni madhogodhanyo, but it's your creation. It's fine.
But
It is your
that
creativity.
now comes to an interesting question, because I'm feeling AI is a medium form, and so would a painting be, isn't it? So if someone decides to paint me and sell it all around,
Yeah.
do they owe me
That is
money?
not copyright. That is image rights, which is a different conversation from copyright. They need your permission to spread your image around. But the painter is the copyright owner. So you might say, mi sikutaka kuonekana huku, sikutaka kupaintiwa. That's a different conversation, which is called image rights in law, yeah? But the copyright belongs to the person doing the painting. Also, you talked about cover songs. So I don't know your understanding of cover songs. Cover songs are not remixes. And you don't change cover songs. Cover songs, you take the lyrics, you take the melody as is. What you change in a cover song is the vocals. So you will hear Eunice Njeri, and then the next time you're hearing Gloria Muliro on the same song, same lyrics, same melody. So you've only changed the vocals, okay? But the moment you are changing sijui beats and changing I don't know what and what, that's not a cover song. That's actually like a remix, which also is a mutilation. You need permission for that, yeah? Yeah.
And I'm guessing if there's image rights, then there's also voice rights. Or now vocals. Is there a way an artist can say, I don't want covers ever done? Though you see churches, I think churches are
Yeah,
always
cover songs, you ask for permission. So the person can say Staki. But as we go along in terms of dealing with violations, we will talk a bit about that. You have the right to say, I don't want cover songs. Yes, you have. But remember, cover songs is also a medium of, you could earn money from it, yeah? Peter.
In the interest of time, I'll try my best to be as brief as possible.
Mm.
Just to piggyback on what she's been talking about cover songs. If someone wants to use a song, not the original, they loved the cover song, whom do they talk to? Do they talk to the person who's done the cover song or the original musician?
If they want to use the cover,
Yes.
they talk to the person who's done the cover, assuming the cover person had permission from the original person. You see, that's the assumption.
Yes.
But those, so there are two different works because the vocals changed. You get? Like now, if you hear me sing and you hear a soprano sing, I'm not a soprano. The song will sound different because of the vocals. So if you specifically want the cover, you need to ask the person who's done the cover. But in this case, Peter, we are assuming this cover person got permission. That's the assumption, because they're supposed to. But we know in Kenya that people don't.
Yes.
Nipeleka nyuma, so I had to open my nini for last. Ona penye mmenirudisha.
Like I said, in the interest of time,
Yeah.
Allow me just to, I'll run through confidentiality. If I've signed a contract and then there's a something that we need to maybe work around, if I introduce it to a lawyer or a manager or an agent, is that breaking the clause for confidentiality?
Yes. If you sign a contract and there's a confidentiality clause,
yes,
it doesn't exclude lawyers, and it's about everyone.
So how do I then get help if I needed maybe assistance from a legal representative?
No, it depends on what you're using that contract for. Like you just brought it, I read for you.
Yes.
And I advise. Okay, that's different. I was talking about I'm using it, or I'm now party to it, or I'm now disclosing that information. Confidentiality clause is basically just disclosing information. But that one you can say, I disclose the information to my lawyer for purposes of advice. So that's fine.
Oh, okay.
Yeah.
Thank you.
But not ati nilikuwa tu na contract wacha ni post online watu waniangalilie hiyo hapana.
Okay.
Now, let me say something about cover songs. Juu naona kuna watu wengi hapa wa cover songs, Hawa ndio watu wa A cover version or cover song is a new performance or recording of a previously recorded commercially released song by someone other than the original artist or composer. It's a re-recorded version of a song, replacing the original vocals with another without changing the underlying melody or arrangement. So you're only replacing the vocals, yeah? In some occasions, a cover song can turn out to be more popular than the original, like this one. For a long time, I never knew that that song was sung by Dolly Parton. Yeah? Everybody knows it's a Whitney song, isn't it? But it was sung originally by Dolly Parton. And then Dolly Parton sang it in a country version. Then Whitney came and sang it. Then it blew up. So nobody knows the original person was Dolly Parton, yeah? But Dolly Parton received a lot of money from the cover. And I read somewhere that part of that money she used to build a safe house in a black neighborhood for women in a black neighborhood. So that tells you how much money she got from the cover song. But this is what cover songs can do. It can blow up, then you lose the original song kabisa. And this is the reason you need permissions. Because if a song blows up like this and you never ask for permission, my friend, hiyo iko shida. Yeah. Wewe unataka kutupeleka mbali wewe. Wacha turudi kwenye tulikuwa. All those things you need permission to use people's works. That is what the general idea is, get permission. If you cannot get permission, pay for a license. Okay? And these things are very nice when you have not made money. The day money starts being made from your work, hapo ndio shida inakuja. They are very nice kama it's just Do you remember the Jerusalem challenge? Yeah, the owners sued. The owners of the song sued. And you saw how it had gone beyond, eh? Yeah. So you need permissions. Okay. Maybe let me start with the other infringement one. Just breeze through a bit. Yeah. So part of what I told you Copyright Board does is enforcement, yeah? And we have a team, what should I call them? Department of Enforcement that is headed by an inspector of police who is seconded to Kenya Copyright Board. And he's been with us many years, so we've trained him on this area. And we have about 10 police officers also seconded from National Police Service. So some of them have worked with us for a long time. Some of them actually ended up doing their bachelor's, went and did the IP masters, and then they transferred service to us. So right now, the guys we have who are still working for the National Police are just about 3 of them. But the rest transferred service. They are now our copyright inspectors. Initially, Copyright Board was also doing prosecution. He told you that I've been a copyright prosecutor, so we were doing our own prosecution until DPP decided to have prosecution go back, all of it to DPP, because they were struggling with some institutions and tracking and whatever, yeah? So now we just work hand in hand with them whenever they have copyright matters, then they can call us in to assist whenever they need the expertise. So what is infringement? Basically, infringement means doing any act that the Copyright Act has talked about, the owner is supposed to do. The acts I told you, distribution, reproduction, adaptation, translation, selling, importing, hiring, all those things, public performance, all those things copyright is saying it's the owner who is supposed to control. So the moment you do that without the owner's permission, then you are infringing. It's provided for under Section 35. And when somebody's work is infringed upon, I said you have 2 courses of action. You can do criminal or you can do civil. Criminal, most of the time you will find, like the cases we deal with, publishers will come and say my book is being pirated somewhere. And then we go we do the investigations. Our officers, the act has given them mandate to enter into a premise, inspect any goods they think are infringing, seize the goods, arrest the person, and then the matter goes to court. So that is what they would do. You also have civil options where you can sue someone. If I feel Peter has taken my work, I can sue him. So the matter will read Sharon Wata versus Peter. The criminal will be Republic versus Peter. And then you have remedies that the court can give you for civil. Either one is called an injunction. An injunction is just an order to stop that person from doing what they are doing. Okay? If someone is infringing on, say, your song, they've put it online, whenever they're given an injunction, they are forced to remove it, to stop doing that. You can have delivery of profits where the court asks them to account for how much they have made with your work, and then they're able to deliver that money to you. You have general damages where you can say, because of the act of infringement, this month I lost 2 million, and the court would award you that much. So remember I said criminal, if they are fined, the fine goes to the state. It doesn't come to you. Most of the time I advise people to use criminal if you want to stop an action or to punish the person. But if you want to gain out of it, civil is the better route to go. Yeah, so you have several civil remedies that the court can give you. So infringement, what is provided for in the act is saying if someone does or causes to be done those acts I was talking about that are controlled by copyright, or importing into the country, then it's a problem. Then you have the offenses also under Section 38. When copyright subsists, any person who does the following commits an offense. Number 1, makes for sale or hire any infringing copies. So maybe you have a song and someone is selling, hiring it, an infringing copy, a copy of it. There's a problem. Remember I said when we are online, when you post something online, it's taken to be reproduction. You have made a copy. Yeah. Selling, letting, or offering for sale infringing copies. So umefungua ka music shop mahali. Like these 2 video shops, it's just that those films are not Kenyan, so I guess nobody cares. But like these 2 video shops where they ban for you films, iko shida. You're not supposed to be doing that. And the moment you begin to do that with Kenyan works, most likely utashikwa. Distributing infringing copies. Infringing copies means a copy you have not been given permission to make. Okay? So even if you come here and start distributing someone's CDs, that is wrong. Being in possession of infringing copies other than for private or domestic use. You have it, but you're not using it for private use or domestic use. When I was in campus, our law books were so expensive. So there's like a guy who used to have a photocopy place, and you just photocopy for guys the whole book. Okay, in the bookshop, your book ni kama 5K. Then you end up paying 5 so something like that. That is very wrong. That is very wrong. But Kenyans unajua, anything goes. Importing, infringing copies. I wanted to look for the one on takedown. Okay, this one is for makes or has in his possession contrivances used to make infringing copies. Like those things you used to burn CDs, yeah? Those equipment, yeah.
I have a question. You know, I like pirating stuff, be it movies, and I'm sure it's something people do here. Like
Conversion.
it's something which is a Kenyan thing. But then again, if you look at some of these sites, like for instance, the Pirate Bay.
Pirate Bay, yeah, that's a pirating site. It's known.
Yeah, the pirate, it's very popular.
Yeah.
But then again, they have this clause that there's that right of access to information. Like you have to put things there and people have to access it. And why hasn't it been brought down? It's been there for the longest. longest time.
By the way, it has always been on the radar of even the international IP enforcers. Pirate Bay is a pirated site, they know, and it's known. So I don't know whether it's a mechanisms or whatever they are unable to do, but that's a pirating site, yeah? Pardon? Open source is different. Open source licenses have been paid already for the works put on open source. So for example, someone says, me, I'm buying things to put here that people can access. Even Creative Commons licenses, that's how they work. It means somebody else has already paid, okay, for those things. But Pirate Bay is not open source. It's a site for pirating. Yes. Open source site means somebody has already paid for that thing, so you're not paying for it again. Creative Commons means the same. Creative Commons licenses. It means there are licenses that have already been paid for. Yeah? So it's like you come here today and then I say lunch is on me, I've paid. That's different from you go into a restaurant and sit down and say so and so has paid. Open source means somebody paid. But that one, the one he's talking about, that's a site for pirating. But ametuambia he likes pirating, so.
So has it ever been challenged? I'm thinking it's there and content gets shared there every day. So
It has been challenged. It has been on the radar for international IP enforcers. Even do you know the police force in London have an IP department, yeah, for enforcement. Those are the people that have always been on their radar. Those kind of sites, they know them. They know them.
is it blocked in certain jurisdictions or?
It probably could be. I don't know. Can you access it from here? Probably in certain jurisdictions it must be blocked, yeah. I'm sure in certain places it would be blocked. Like China, I'm sure. Do you know, I was in China last year and I couldn't even open my Gmail. Like that simple, Gmail. I couldn't even access WhatsApp. So certain jurisdictions would block certain things that they don't want, yeah? So it's possible to do that. Yeah.
Okay, so contents, not all contents are under copyright, right? So it's better that mtu aulizie permission from the
Oh, you
owner.
mean not all content are protected by copyright?
It's a question.
Oh, no. All content created is protected by copyright. That's the rule of thumb to assume. Okay? Assume that everything is copyright protected until you have information to the contrary. So even when you see something online that's accessible, assume it is copyright protected. Why? Because registration is not what gives you copyright. What gives you copyright is creating and putting it out there.
Okay, so I was going through TikTok and there was this certain content that I saw that it will really fit in my script. So
by content you mean music?
No, it was just
or written
like
content.
comedy. Something like comedy, just a simple act. So I went over and asked the owner of the content, but she gave me permission to use it, but she told me that she was not the original owner. So my question is, I want to use content, other people have used it, and let's say that it was very viral. So about 100, 1,000 plus people used the content. Would it be wrong for me to use the same content while other people use the same content without permission?
Okay, so I'll ask you a question to answer your question. I need 5K and I don't have. Would it be wrong for me to steal from Jemima? Because other people also steal.
No.
Would it be right to steal?
It wouldn't be right.
Yeah. So the right thing to do would be to ask the original person for the permission. Most people don't even know the original person. If it's a viral content that has gone viral, and you probably don't know. So that's why we just use and hope sitashikwa, and probably utashikwa. The only problem for me with that is that I am also forming a habit. I'm also forming a habit of using content without permission. Then one day it will catch up.
Okay, so the owner of the content alinikubali nitumie hiyo content yake. So can I say
Yake
I
hiyo
used
yake.
her,
Yeah.
hers,
Yeah.
even though it was same as the other one, the original,
Yeah.
but can I say I used hers?
Yeah. Hers is okay. You see, the thing with copyright is this. Copyright protects your thing, whatever you create. So me and you can decide we are doing, nobody can stop reggae. It's an existing song. You do it, I do it. We've sung the same words, the same whatever. Even if it's an infringement, you're still protected by copyright for your version, your creation. It's just that if it's an infringement, then you have a problem with the original owner. I will be protected for copyright for my version. But also, if I don't have permission, I will have a problem with the original owner. So you can use hers, the one who gave you permission, if you're using hers as is. But the moment you create your own, then that is your own. That's what hers. Even if it's the same thing, even if it's the same song.
Even if you change it a little bit.
Yes, you're creating your own. That is yours. It's not hers.
So it is mine.
Pardon?
So it is like mine, even if
it
I
is
change
yours.
a sentence.
It is yours, even though it's stolen. It's like I said earlier, I borrow somebody's car and I change the color because I don't like the color. Or I steal somebody's car and I change the color. I've still stolen. That's the thing, yeah.
Okay, now another question. Let's say my friend and let's say I wrote a song and I shared it to my friend. So maybe we stayed together, we used to sing the song, and then due to unavoidable circumstances, we part ways. She goes maybe another part of the country, and I stay maybe in Nairobi, she's in Nakuru. So my art was not under copyright. It was just something that I thought of and she liked it. So
Okay, wait. You wrote the song and sang it. Is it somewhere accessible? Like if this guy wanted to get it, they would get it.
I don't
Is
think
it
so.
online? Is it in a CD? No. You are the one who just has it.
Yeah, you just write a song and then you share it to your friend, and then you part ways, but your friend gets to produce it before you.
It would be up to you to prove that you gave it to them. So that will be your word against us. It will be up to you to prove that you gave it to them. And that's why we were talking about contracts in terms of whenever you're sharing information, sign NDAs, if you're having collabos, sign contracts, yeah? Okay. But again, if you can show they stole it from you, you would have a case. Yeah. This is one of the offenses I wanted us to see, circumventing a TPM designed to protect copyright. TPMs are technological protection measures. So for example, there's a group from South Africa, I like Joyous Celebration. Their songs on YouTube you can never download. Hiyo lazima ununue tu hiyo DVD. Na inakuanga $7, sijui ngapi. But when you go to YouTube, you can listen, but you cannot download. But then I was told there are IT people who can help you get around that. Okay? That is what the law calls circumventing a technological protection measure. If someone has disabled download from their content and you're still able to get it through a circumvent, yeah? That is one of the offenses, especially when we are talking about the digital arena. It is an offense. And if someone does that to your content, you can also complain, yeah? Removing, altering digital rights management information or making available to the public a copy. The same thing I'm talking about, like sana with the books, for example. I have researched books where it gives you a page, you read, you're like, yeah, this is what I need. then ukienda kwa download inakupeleka kwa payment. But apparently the IT people who the act, you can see these penalties, but I'll share this so you can go through it. I'm just trying to save some time. So the investigation process, when you come to Kekobo, write an email, because we receive also complaints through letters, emails, or people come in person or phone call, they'd have to record, yeah? They receive and document the report. Then they gather evidence in relation to ownership details, like the matters we deal with. Books, for example. Like one time I remember someone came and said from a publishing house that their book, fake books were being sold in a certain bookshop. So our guys will gather evidence. They'll go to that bookshop, they will buy that book, the fake one, they will get a receipt and leave. That is part of their gathering evidence, yeah? You won't even know these are copyright board inspectors, yeah? They will establish where is that bookshop, who is the owner, because sometimes you can go to a shop and arrest somebody, kumbe it's just an employee. You have to establish the details, yeah? Then they identify the mode of infringement that it's happening, whether it is tangible works or digital platforms, social media, streaming places, all this, yeah? They visit the crime scene. If it's the bookshops, they go there. With the broadcast signal, we have matters we do for multi-choice, DSTV. So you know the DSTV Sambaza. So they will go to the premises where these things are being done. And let me show you. Those DSTV Sambaza people, this is the kind of rooms they have in their houses. Apata mtu set up hivi. And they even use electricity poles to transmit whatever they want to transmit, yeah? It's usually an operation. Let me say that. So a guy is in Umoja. He's ambassadoring DSTV full package to 1,000 houses. And everybody just pays 1,000 per month. So he's making money. Ya na yeye amelipia tu package moja peke yake. So those are some of the matters that we deal with. And so they'll visit the crime scene. They involve other investigative agencies like online. Sometimes we have to use the DCI at cybercrime at DCI, the cybercrime lab, to check for us some things. We have collaborated with PPMC also in the past to help us analyze songs, whether they are similar or not. And then they, when they are at the crime scene, they identify themselves, they secure the scene, they will pick whatever is infringing. They will arrest the person, and then they prepare an inventory. They will say maybe they found you with 50 books or 30 or 20. And there are times we've figured court when I used to do prosecution and someone says, mi nilikuwa tu na tatu. So you have to get an inventory and they sign that, yes, you have found me with 2, 3. And sometimes they refuse to sign, yeah? And then usually the matter is taken to court. Nowadays, DPP would deal with the prosecution. Some of the works that we have seized that are pirated, like software, there's even a case we dealt with, but we tried to do mediation on that. These two guys worked together. One was a software developer, the other one was a business guru. And then there was a software that was developed for hospitals. Then they parted. So this one, the business one left, took that software, continued selling in hospitals. Now huyu mwingine anasema, this is my software. So you'll find softwares that are pirated that people use. Literary works, books, we do that a lot with the publishers, local publishers. This is the picture you see is like when we do destruction, because after the case is done, the court will give us the infringing items for destruction. So we are able to have them destroyed in a safe manner. Because most of them are CDs, books, these DSTV boxes. Yeah. So now, as I finish, I want us to talk about how to handle copyright violations, yeah? And this one, I prepared it in mind with the online in mind mostly, yeah? Because that's where violations are now happening more, because people have moved online, yeah? So number one, you need to identify the infringement, clearly determine if your work is being used without permission, including the specific elements being infringed upon. Is it your text? Is it your image? Is it your music? Is it your, what exactly? Be sure what you're complaining about, yeah? Gather the evidence of the violation, like get the screenshots, links to the infringing content. If it's a content infringing online, get the link. Because even if you get a lawyer, they will need these things, yeah? Contact the infringer directly, send a cease and desist letter politely explaining the copyright violation, requesting immediate removal of the infringing content. But also the Copyright Act has given you provision to issue a takedown notice to an ISP to take down any content, any of your content that is being infringed upon. And they have that obligation. That if my content is being infringed upon on a certain space, you can issue a takedown notice to the ISP to take it down. Provide clear instructions on how you want the infringer to comply, and contact information for further communication. Because mwingine anaweza sema, I tried to contact you, sikukupata. You get? So you need to provide all that information. I want you to stop doing this or to do 1, 2, 3. You can get in touch with me here. 3, consider mediation and negotiation, because, of course, court is tedious and long and takes a long time. And sometimes the infringement is continuing to go on and you're losing more, yeah? So it's also good to consider this. If the infringer is willing to cooperate, explore options like licensing agreements. Tell someone, let me give you a license. Let me do this. Let's do this, yeah? I know you have heard about the case for Nonini, where someone infringed upon his song being used in an advert. To me, when Nonini first complained, if I were that person, I would have reached out and said, okay, how do we, in retrospect, work this out? Can you give permission now, then we pay? Something like that, yeah? But they went to court. They were fined $1 million. They appealed. Upon appeal, they were fined $4 million. Aki Peter, you're a hater. Unacheka. Umesikia tu. So ikasonga, you see, which, if you ask me, it may even have just been a nice settlement. Hata labda wangeongea tu na waseme, let's give you an M na ishia hapo. Yeah? So it's always good to consider negotiating, especially if the other party is also willing and palatable, yeah? Yes. No. When it is in court, it's out of your hands, although you could tell the court that we want to try an out-of-court settlement. So usually they give you time, go and talk. If you agree, you come and record the consent in court. You come and say, so tumeongea na Peter, tumekubaliana, atanilipa 500, you record it in court so that the matter is closed. Because you see, in court, it's already a live matter in court. So yuwezi tupwa tu nje hivyo. So they'll tell you, sawa, go, talk, then come record the consent in court. Then it is recorded. That's how it ends, yeah? Because remember, once you have sued for certain thing, you can never sue again whenever that matter is done on that thing. So if I sue you for violation of copyright on a particular work, na hiyo kesi imeisha, I can never come back. So you need to exhaust all your options when the matter is live. Eh? Seek legal advice. Consult with an IP lawyer if the infringer does not respond to the cease and desist letter, or if the violation is very significant. Again, you need to ask yourself, is this violation very significant? Does it take away from me? Am I losing? How much am I losing? Because sometimes ni vitu kidogo kidogo you can do away with, yeah? I always tell people, us lawyers, we are experts in everything. Eh? So if you come to me today with Children's Matter. I won't tell you sijui. Tell later hii kitu tufanye. Then what do I usually go first? My class, my LLB class ya UN Parklands. Then hapo niseme, nani ufanya Children's Matters? Ebu I need to consult. Then unauliza, then unafanya ka research. But the truth is, I'm not a children's lawyer. So when sometimes people tell me, I've talked to my lawyer, my IP lawyer, and then I ask, nani? Because tunajuana. And then they're like, who the hell is that again? Consult an IP lawyer, please. And make sure your lawyer is an IP lawyer. Sawa? Unajua lawyers are learned friends. So, hatukatangi kazi. Tutaenda kufanya research. Tunafanya research ingine kali sana. But you can tell somebody who knows their stuff and somebody who doesn't know, yeah? So, a consultant, intellectual property lawyer. Oh, and yeah, we can give you recommendation at Copyright Board. The lawyer can advise you on the best course of action, including atakuambia, let's negotiate, let's go to court, let's do this, They can tell you when you can seek for an injunction, for damages, and all that, yeah? Important factors to consider when you're thinking about how to handle your copyright violation. Severity of the infringement. Is it that severe? Will it really take away from you? Does it change much? Has it altered your work that much? If you're willing to spend, say, 5 years in court, it really needs to be a severe thing, eh? And it really needs to be something that enyewe, hapo unaona you have lost, yeah? The scale of the violation and the potential harm to your work. Alafu unajiambia hapa, how much will I lose, eh? Fair use considerations. You need to also check, is this use within permitted uses? The ones I said, we talked about them last time, what are they called? Exceptions and limitations. Because copyright has given certain exceptions and limitations. The copyright law says, for example, if I'm using something for research, you're allowed to use for private use, for news reporting, in judicial proceedings. I am in court, I'm giving evidence, and I show a video. That is allowed. For news reporting, you have seen when guys are reporting news, sometimes I make up amesema amateur video. It means yeah, somebody took it. So such things are permitted within the law. So you need to check this use. Was it wrong? Was it right? You remember some time ago we had an issue with some musicians, their song being used in a campaign, and they raised an issue about synchronization rights. They knew what they are talking about, yeah? Of course, with Kenyans, it was an emotive thing, and it's because it's a public figure that we love, Yeah, but truth is, there was a violation. So you need to know, is this permitted or not? Synchronization rights must be sought from the owner of the music. That is the law. If I am going to have synchronization, I need to seek permission from the owner. Yeah? And the law doesn't change because I am Mrs. Wata, the IP lawyer. No. The law is supposed to cut across to everybody, yeah? So you need to check, this violation I am claiming, is it part of what is allowed in the law or not? And then the jurisdiction, copyright laws vary depending on your location, so understanding your local regulation is very crucial, or the regulation of where the violation is happening. Eh? Just last week I was dealing with some gospel musicians who, you record a song, I think one of them, she released it on 31st December. And then someone went and put it on YouTube already. So she had received a notice from YouTube that they're going to pull down her content, because then they think she is the violator. And then we wrote a letter for her telling them that this is the owner of the music. She has even registered her songs with us. And they still went ahead to pull down her content. And this is a very well-known musician who has a lot of subscription, So that, of course, is going to affect her earnings. Now, if she decided she wants to go and sue, she would have because the company I saw is based somewhere, I think in Germany, she would have to understand, the lawyer would have to understand the laws operating there. Because then you can't use Kenyan law to go and sue somewhere else. And also you need to make that decision. That's why you need a lawyer. Am I suing here? Am I suing there? Because usually you have to sue that company, for example, where it is registered. But you'd have to, yeah. Yeah. Mm.
You are a Kenyan and you made a song, and let's say it's getting airplay in Uganda. Does Kekobo, or how is the jurisdiction in terms of following up? Is it the role of Kekobo, and if so, how does Kekobo help with that?
You mean getting airplay means what? It's just being played there in the media houses?
Let's say you have an issue maybe regarding permissions, giving permissions, or collection of royalties.
Okay. With collection of royalties, it's done by CMOs. That's the role of CMOs. So what happens, or what is supposed to happen? CMOs are supposed to sign reciprocal agreements with CMOs in the other country, because they cannot go to another country to collect. So they sign an agreement. So say MCSK would have to sign an agreement with the MCSK of Uganda, so that those ones collect for you and these ones collect for Ugandans. And then there should be an exchange of the revenue collected. So with collections, you cannot go to collect in another territory. With violations also, we can assist you to get in touch with the copyright office there to help, but we cannot do anything in another country, because every country has their own laws and every country operates with their own laws. So laws don't cross the border. But if it's a nation especially that has signed the Berne Convention, which Kenya has signed, then they have an obligation to protect your work the way they protect their people. We have an obligation to protect foreign works the way we protect Kenyan works. But if there's a violation, that person would have to come and sue here. If there's a violation, you would have to go and sue in that other country. And of course, it's expensive and tedious, but again, that's where we come back to assessing the severity. Yeah? Is it that severe? Can I really afford to even go and sue there and all that? Yeah. Yes.
So in regards to that, if I discover I'm being played in South Africa and Uganda and whatnot, like say 3 countries, like, can I, as an artist, register with the CMO of that country for me to collect directly from them?
It depends on their provisions. Like I know in the US, they'll tell you, enda utoke kwa hiyo ya Kenya, then you come and register. And I think that's what Nonini did. He had to exit here, then go and register in the one in the US, yeah? So it depends on the country and their provisions. I have known Kenyan gospel musicians whose works are played in Tanzania, like Ruben Kigame. And there's a time the copyright office there reached out that they have his money. But they were saying he has to go and register. He has to do some registration with them, because they were also doing the collection, yeah, to be able to access that money. So sometimes when you see that money and then you convert it, you're like, okay, it doesn't make sense, because you need a registration fee, you need to go there, yeah. So those are the things you have to put in place. But he is free to access that money with Tanzania, for example. But it's because Tanzania, they know us, we have a relationship, so they'll reach out and say, do you know Peter Kawa? We have money for his works here. Then you say, okay, yeah, we know this person, we can facilitate this.
So in short, with the mess with MCSK, we cannot collect money outside this country.
You can't directly go to collect outside this country.
No, since MCSK is signing treaties with the other countries.
I didn't say they are signing. I said the ideal situation.
Yeah.
They should have signed a reciprocal agreement.
Yeah. So it means even if they are receiving money, still the money cannot get to the artist.
You don't remember the last altercation issue we had with them about distribution and whatever, there was certain amounts said they had received from Google and from Samro in South Africa, which they had not declared, apparently. So that was an issue. But you can see they are supposed to receive. They're supposed to receive from some of these places. So then they're supposed to put in that pool and distribute. But also, the ideal situation should be whoever is giving you should also give you a list of who is supposed to be paid. Like that country should have known they collected for Sharon and Jemima and Peter and who. So they should give you that list that we're giving you 10K. These are the artists that we have collected for in our country. Because not every Kenyan artist is played there.
And let's say I'm a global artist and I place my person in South Africa to get the logs for me and track the plays. And can I go to MCSK and demand for the money because I have evidence that this is the amount of times I was played and this is the money that I'm reclaiming from this other side?
That's assuming that wamepewa hiyo pesa. You can go and they tell you hatujapewa. That is assuming wamepewa. And again, this is the catch-22. We are relying on them to tell us tulipewa ama hatukupewa. See, we are relying on them to tell us we were given or we were not given. Because you see, as Kekobo, how would I know? I wouldn't know. I'm relying on their reports. This is how much we collected. We were given this from South Africa. We were given this from UK. Yeah? I'm relying on their info.
But if there's all this mess and we have a government, why can't they withdraw certain tasks from them? Because I don't see why a private company should be messing up things for an industry when we have a government that is making the laws.
That's why I said finally about the issue that there was a pronouncement made by the president on 12th of December about Kekobo and other stakeholders making sure there's a system that can be used to collect and distribute rightfully. But you know, everything you have to do within the bounds of the law. So I can't wake up and do anything that I don't have a mandate to. So if it means changing the law, you have to do that. If it means creating a law, you have to do that. That's why I said some things are still going on in the background to see how to create that. Because it's already a presidential directive that was given on Jamhuri Day in front of everybody. So you would have to find a way of executing this thing, but within the law. Because if you just wake up tomorrow and say, okay, this is what you're doing, you'll be in court. And the courts are bound to follow provisions of the law. First thing they'll ask you, where is your mandate to do 1, 2, 3?
Well, on another thing, are these contracts and split sheet a thing that an artist is supposed to create with the lawyer, or does Kekobo provide like certain guidelines that needs to be followed?
Oh, no, they're not guidelines that needs to be followed, but they're templates for, what should I call? Generally accept, best practice, okay? And so we can give you guidelines and we can give you sample contracts where if you go somewhere, you will look at it and look at your contract, the sample and see, but a contract is just that, remember where we started, an agreement. So it's just what we agreed and how we decide to put it down. But now when you have some guidelines, you know, hey, there should be an exit clause. Hey, there should be a governing law clause. Hey, there must be this. At least those ones will guide you to know how to make it, yeah? And then, of course, and that one is from the contract law. There's a standard that this is how contracts are done, yeah?
So when it comes to drafting, I have to do that with my lawyer?
You can do that with your lawyer, but you can come for help. That's what I said. If you needed to draft, you can come for the legal help at Kekobo.
Okay.
If you needed to draft a contract. But I can send the samples so you can have them and look at them, the sample contracts that we looked at, yeah. Okay. I can share with PPMC, then they'll share with you.
Okay.
Yeah, because you did the registration, right? Okay, do we have any other question, or would you people allow me to go and have my ugali now?
There's one. Oh, 3. I thought it's one.
You guys, I'll fall down. I'm hungry.
Okay, we are taking 3 questions and we wrap up. So, wow.
It's okay. It's okay.
Let's take 4.
Okay, Kekobo does mediation and then legal advice.
Yes.
Do you do litigation as well?
Yes. But no, not for private, yeah?
Uh-huh.
You see, we're government, so we can't do litigation
Uh-huh.
for private parties. We do criminal. If you report to us, we can take that as criminal. But if you needed to sue me, you'd have to get a lawyer, but not from government. Yeah?
Okay.
Yeah.
Thanks.
We do, like last week, we had 2 guys who were saying, this one says, this one took my song. We actually came to PPMC. They helped us to do the analysis and have a report of whether this is similar or not. And PPMC is very thorough on the analysis. They'll tell you about the lyrics, the beat, the whatever, the structure, the theme. And we are able now to come up with a report of, okay, these are similar or they are not. So we sat them down to say, okay, now let's talk about this. So that is part of what we do. We really encourage people to just sit down and sort out and avoid court. And sometimes you can find even that sitting down to sort out, you might come up with a partnership more than a fight, yeah? Our lawyers are court-annexed mediators, so it is professional mediation. So it's not just at the mini referee, I'm just a referee, no. It is actually professional mediation.
Okay, so talking about contracts, I want to involve children in it. So who's responsible of signing for the children? And also, is there maybe Ministry of Labor or Labor Office involved in case of child labor?
No, children don't have capacity to sign contracts. Wewe ulikuja umechelewa. Hebu toa fine uweke hapa kwa. Nitaitumia kama fare. I said you need to have capacity, and part of capacity is that you need to be of age to sign a contract.
What if it's a child who's involved in the...
If it is a child, their parent or guardian can sign for them, but whenever they are 18, they need to make that decision for themselves. Yeah.
Okay. And an actor child.
Yeah.
So does the child have rights to the money, or if the parent signed, the parent gets all the money?
The child has a right to get their money, but the mother is administering the money, or the father, you know? So that's their family affair.
When they turn 18, can they ask accounting of the expenditures and be like, there's a balance?
I wonder if they can do that with a lawyer mother like me. I carried you for 9 months, my friend.
That's what I guess.
I guess they can.
Yeah, like maybe if it's a case like they want to go to school and they're like, no, there's money somewhere, and they want fact finding so that they...
I don't know. Maybe somebody should try. But you see, I am in charge of you until you turn 18. Okay? And if I could carry you for 9 months, my friend, I can make decisions, good decisions for you. If you feel you have a problem, so I end up continuing. That's the whole idea. A child cannot make decisions for themselves until they attain the age of maturity.
Hi, thank you again. Just 2 very quick questions. I saw on the contract there's a space for a witness.
Yes.
Is a witness necessary? And
yeah,
second question.
It's good to have a witness. It is good and necessary to have a witness.
It's necessary?
Yeah.
Second question, if I come to Kekobo, do I speak to a different person every time, or is it possible to have a specific person I deal with?
You can ask that I want to see so-and-so, but also it will depend on their availability. Yeah? But in a government office, the ideal setting should be that you can get help from anybody when you come. Yeah, but you have a choice to ask for a specific person. But we have, I think now we're only 3 legal people. Yeah, we're now only 3. So most likely if you come, if you didn't make an appointment and you came, you'll be given the person who is there, who is available, yeah? But they're all good. They're all IP people. They have done a master's in IP. So you would probably be helped.
Hi. Firstly, thank you so much. Like, this has been so insightful and I've learned so much. I wanted to ask, would There's like a situation I wouldn't know how to go about. I don't know if I ask her in public or can I come to you, you might attend.
Yeah, you can find me.
Okay.
I can help you.
Okay,
You don't have to.
air my laundry.
Yes.
The second one is I've heard someone say, actually a fellow musician, that it's very difficult for you to get paid royalties without having a publisher. How true is this? And maybe some more insight on the matter.
Publishers basically just do your marketing and your distribution and whatever they sell, yeah, and they can get you new users for your song. It's not a must to have a publisher, and that one shouldn't legally bar you from getting your royalties. What you need to find out is the structure of the CMOs that you're dealing with. Are they the ones saying you must have a publisher? Which I don't think, because I know, like the ones here, they have individuals as members, and somebody is able to get paid by, directly, yeah? So that is not a very sound argument. Probably they should tell you, I would advise you to have a publisher, because maybe a music publisher will have more negotiating power for you, or I don't know. But it's not a must to have a publisher. I'm sure it has its own advantages, and if you can afford to, but it's not a must. And that is not a reason why you should not get paid because you don't have a publisher, no. Okay, guys, before we end this, Baby Black ako wapi? Hata nilikuwa nafikiria leo umelenga. Kuja utuangushie kawimbo tumalize. Hatuwezi kuwa hapa wasanii tumeboeka hivi. Fanya ile kitu.
Before Charles alikuwa ameuliza, can you copyright jokes as you rapper?
Yes.
Yeah.
Okay. So if you package your jokes in a book, you can copyright the book. Okay? You can register the book for copyright. If you publish, or not let me say publish, if you package maybe those jokes in a book, yeah? But not that itu nimesimama hapa nimewambia ka jokes. Hata mimi nimewambia ka joke leo. Then how would I copyright that? Yeah. Now, the producer of the show is the one who can copyright that show. Yeah? Because it's not, you're not copywriting yourself or what, it's the whole show. If you can record, you can copyright the recording. Yeah. If I'm going to a restaurant to do just stand-up comedy and then somebody is recording for me, I can register that recording for copyright that show.
In a rally.
Okay. So this is how copyright works. Na wewe ulikataa kuja last week. That's why uko na maswali mingi. So next time we're having, you come again. Ndio usiturudishe nyuma. We said, mko wengi newcomer, which is okay. We said that copyright does not copyright ideas. You copyright what you have created. So for example, I could give you an idea now. All creatives here niseme, kila mtu tengeneza kawimbo about love. Ama nitengeneze ka birthday song. It's my husband's birthday. That's the idea. So I'm not copywriting. I'm not protecting that idea. Nobody else will ever use it. I'm copywriting every song that every person created from that idea. So you need to separate just an idea and say, because I came up with this idea of stand-up comedy first, nobody can ever do it. No. You protect your expression of that idea, how you express that idea, the things you come up with. But you protect them packaged in a certain form and accessible to the public.
It's coming up, like, I don't know if you remember the copywriting of Allah and...
Hizo ni jokes, wewe.
Exactly.
Tuko serious? You can't copyright something like that.
But
in fact, nilisikia, it wasn't copyrighted.
A joke,
that Allah was
joke.
supposedly trademarked. And you know, a trademark, you're even supposed to register a trademark tied to a class of goods that you want to use them on, because it's business trademark. So I don't know how that works. But of course, see Kenya, as long as you're famous.
Okay, but I'm just saying,
Yeah.
you say like, I want to do a cover song, let me get permission, right? So there was that stand-up comedy, and then I retell the joke. Does that need licensing?
Yeah, if it's somebody's original, and you can tell this is their original thing, you have to ask for permission. So as we're going to finish, let me say this. Number one, let us assume everything is copyright protected, okay? Even if it's accessible online. Assume it is protected. You're safer that way. So if I want to use it, let me look for who to ask for permission. And if I can't get the person, find something else to use, yeah? For example, pictures, even the ones I use in my PowerPoints, you can get pictures from Creative Commons licensed places online, yeah? There's a pool. There are people who have already paid for the license, so you can pull out this and they're usable. But if you take someone else's, then without permission, that will be a problem. So let's assume. Yes, those ones you have to find out, are they under the Creative Commons license? And I think that Getty, they are. So you need to find that out. If you don't know and you're not sure, wachana nayo.
The crediting, is it that if you don't download it, you have to keep the image?
No, if you find an image that you are able to download, it probably has allowed you to download. Yeah.
But if it has no download and it has that mark, because usually it's the same way even our own photographers.
Yeah.
You have to download ndo sasa upate bila
the watermark, yeah. But removing the watermark, remember I said it's what? Removing DRMs and TPMs, it's a problem. So you don't remove the watermark from something. You leave it there. Because you're not trying to pass it off as yours, isn't it? You just want to use it in a PowerPoint, so it's okay for it to have the watermark.
Kenya ni yetu, twende mbele pamoja, tufanye kazi pamoja, tukifurahia umoja wetu, tusonge mbele pamoja. Uhusiano kama wa Kenya uimarike, nishike mkono, nikushike mkono.